Support court with Judge Vonda B sent me a cease and desist letter threatening to sue me because... What's going on, y'all? Attorney Tom here. In today's video, I'm going to be going over the cease and desist letter that I received, as well as the response that I sent to support court with Judge Vonda B's legal team. On July 21st, 2021, I created a video titled Working at 7-Eleven to Avoid Child Support / Lawyer Reacts. This is a react video to support court with Judge Vonda B's video. I'll just play the intro of it so you get the gist.
I'm not about to play with you. You came obviously in this courtroom to waste my time.
What's going on, y'all? Attorney Tom here. Today I'm going to be reacting to a video called Child Support When Parent is Intentionally Underemployed by the YouTube channel Support Court with Judge Vonda B. You know what? I'm going to keep this. That was a great place to pause. Anyway, I created this video. It's 12 minutes and 34 seconds long. In the description, and this is important for later purposes, I tagged Judge Vonda B's channel. The very first thing in the description says, check out Judge Vonda B's YouTube channel here. And I linked her YouTube channel. But what probably a lot of y'all don't know is on top of running the YouTube channel, the AttorneyTom brand or media company also has a pretty big Facebook page. And I don't blame you if you don't know it. I personally don't use Facebook. We have a Facebook page and we actually don't manage the Facebook page. I've partnered with a company that specializes in working with popular YouTubers. So in 2022, they took the Judge Vonda B reaction video, re-edited it. You can see here it's only 7 minutes and 41 seconds long, where the YouTube video was 12 minutes something long, and they posted it on the Facebook page. And I'll play the intro to this video.
I just found out my wife just left her corporate job for a cashier job. I don't know why. Maybe it's because like she wants to get out of the payments of what she's doing.
Okay, that's pretty fitting. The name of this video is called Child Support When Parent is Intentionally Underemployed. Intentional. God, do I always make weird faces when I pause? Okay, so I'm getting distracted. Basically, what's important here is they re-edited this video. They uploaded it on my Facebook page, but when they re-uploaded it on the Facebook page, they didn't give Judge Vonda B the courtesy of linking her profile. And that's the whole crux of this issue. It's not a fair use issue. I think they even acknowledge that from their letter, which let's just jump into it. Okay, so here's the cease and desist letter I got. Let's go over it. First things first. They spelled my name wrong. It's Kher, Kher. If you're going to send somebody a cease and desist letter, please just, spell their name right. It actually hurt my feelings. Please be advised that this firm represents support court with Judge Vonda B. In this formal demand that you immediately cease and desist from all violations of Vonda Bailey's, Miss Bailey's intellectual property connected to support court, including but not limited to any and all copyright and trademark matters. As you are likely aware, Miss Bailey is the owner of all intellectual property associated with Support Court, a courtroom-based television show that broadcasts across various online media platforms. Support Court wishes to settle this matter promptly and amicably. As such, it has requested that we lay out all the factors to be addressed in consideration of reaching a resolution. For reference, throughout this letter, you and you should be broadly constructed to include Tommy John Kherkher and or AttorneyTom alias. On February 24th, 2022, a video was posted on your Facebook profile captioned, "She changed her job to stop supporting her child," which included several minutes of support court footage that included Miss Bailey's brand likeness and image without specifically crediting the source of the footage throughout the video or anywhere in the caption or comment section, effectively failing to make it clear that the used footage was not your property. Now, before I continue reading, let's watch that intro again.
I don't know why. Maybe it's because like she wants to get out of the payments of what she's doing.
Okay, that's pretty fitting. The name of this video is called Child Support When Parent is Intentionally Underemployed. Okay, so as you can clearly see, yes, the re-edit of the Facebook video doesn't have the part where I affirmatively say, hey, this is what we're reacting to, Support Court with Judge Vonda B, but it shows the name and title of the video as well as who the video is produced by. I don't think any reasonable person would have any doubt that I'm reacting to a video. Additionally, that whole argument is irrelevant, which I'm gonna get into later. March 1st, 2022, you later include a detailed disclaimer in the comment section of the video, also linking to your website. The disclaimer read, "This content is property of AttorneyTom LLC. However, nowhere in any of the original or additional commentary did you directly credit the intellectual property works of Miss Bailey or support court specifically." Okay, so this right here is the comment in question. This is a comment that I standardize on every single video. Every single video that I post ever. YouTube, Facebook, it's there. I'm a lawyer. I gotta disclaim things. I gotta be a lawyer. It has nothing to do with claiming intellectual property rights. And guess what? Under fair use, it is my video. Just because I'm reacting to an underlying work that is Judge Vonda B's video, me reacting to Judge Vonda B's video is still fair use, and it is still my property because it is my reaction and it is transformative. Intellectual property rights exist to protect creative works of those who produce them. To establish a copyright infringement claim, a plaintiff must show both ownership of a copyright and unauthorized copying by the defendant. Similarly, under trademark law, a plaintiff must show a protectable right in a mark that the defendant's use of the mark creates a likelihood of confusion as to mark source, affiliation, or sponsorship. This video has now garnered over 4.5 million views, 7.1 thousand shares, and over 7.2 thousand comments, making this a serious matter that threatens Miss Bailey's branding and reputation. This video, as well as the added disclaimer, have proven to be extremely misleading to the public, causing a likelihood of confusion regarding the ownership of the source of the video. Thus, it is necessary that you cease and desist from the use of the source video on the online platform without proper identification. Two really important things. First, trademark, that's completely irrelevant. There's no trademark dispute here. No reasonable person is going to confuse AttorneyTom for support court with Judge Vonda B. I'm very clearly just reacting to a video. Second of all, branding and reputation, I'm actually very kind and nice to Judge Vonda B. Before receiving this letter, I actually really enjoyed her content. I say that over and over again in the videos. She's a cool creator. At least that's what I thought. And again, it really wouldn't matter whether I was nice to her or mean to her in my analysis of the video, because that's not how copyright infringement or fair use works. That's not how any of this is determined. Accordingly, we hereby demand that you confirm in writing within 3 days of the date of this correspondence that you have properly identified support court in your posting by including the source link, tagging Miss Bailey or support court in all platforms where your video is located, or promptly remove the February 24, 2022 video on all platforms if you refuse the above. Although Ms. Bailey is looking to reach an amicable resolution in regards to these matters, I would like to emphasize that should you fail to comply with these demands, we will promptly initiate any available legal action without further notice. We will be seeking monetary damages for the harm suffered due to your actions. Okay, so there's essentially my ultimatum. Tag support court with Judge Vonda B in the Facebook video or get sued. Let's see what I said in response. Dear attorney, I find it unfortunate that I have to meet a fellow member of the Harris County Plaintiffs Bar under these circumstances. So I guess further context, she hired a local Houston plaintiff's attorney. I'm a Harris County, Houston-based personal injury attorney. This person is my colleague. So I'm just extending some professional courtesy. He/she, they're just doing their job. So I have no ill will or disrespect to them at all. I've received your letter on behalf of your client, Vonda Bailey, regarding a video posted by my media company, AttorneyTom LLC. In short, your letter seems to misrepresent the factual situation while not citing any substantive law. Your letter fails to address any well-established principles of fair use. I will not spend the time going through an exhaustive fair use analysis for content that is clearly transformative. Absent additional information and proof of your claims as requested below, AttorneyTom LLC will not be taking any actions set forth in your letter. And again, I did this, one, because I didn't want to spend the time going through a whole fair use analysis, and two, based on their letter, I think it's pretty clear that they even admit that it is fair use. That was not really an issue that they brought up. It appears that Miss Bailey is asking to be given credit in the description section of the video, while the creator who publishes a transformative video under the fair use analysis has no obligation to link the underlying work. This is a courtesy that we routinely extend from the onset of publication. In fact, Miss Bailey's YouTube channel is linked in the description of my original video published on July 21st, 2021, and I showed a screenshot of it. I partnered with an affiliate company that specializes in managing Facebook pages for popular YouTube creators. The affiliate company re-edits and posts creators' YouTube videos in a manner that is optimized for Facebook. This is done automatically without the original creator's oversight. Here, the affiliate company repurposed the AttorneyTom LLC's original YouTube video published on July 1st, 2021, and published it on Facebook in February 24th, 2022. Damn it! Grammar issue. Shit. Already sent it. It's too late now. It's too late now. Move on. Y'all, the next two words are something you're never going to see in a demand letter, but this is my freaking case. I get to control it, so I'm gonna try to change it up. I apologize that the affiliate company that re-edits my YouTube videos and formats them for Facebook did not extend this courtesy automatically. Had Miss Bailey reached out to me and asked me to include the link to her channel, I would have extended her this courtesy without hesitation, despite not having any legal obligation to do so. However, hiring a lawyer to intimidate and bully an independent creator is unacceptable. I'm in a unique position as an independent content creator and a lawyer where I can stand up to bullies who threaten a baseless legal action as an intimidation tactic to impose their will. This is not a responsibility I take lightly. Therefore, I must decline Miss Bailey's demands because of the way she went about this. And y'all listen, as many of y'all know, I'm a catastrophic personal injury lawyer. My law firm sues the biggest and baddest mega corporations in the world. How could I, as somebody who encourages my clients or members of the juries to stand up to bullies, sleep at night if I cave to this baseless demand solely because it's my time, my money, my livelihood, my neck on the line? I would be a fraud if I did. I could easily fix this, tagging them in the comments. That will take me 3 seconds at most. But hiring a lawyer to intimidate, to bully, it's really disheartening and it's really sad, especially from a court-related TV show. Because the way I see it, I'm not doing this for me. I'm doing this for all the other content creators. I run my own law firm. I have 3 lawyers. I have 3 offices. There's probably not another independent content creator on the planet who is uniquely qualified, has the resources, has the time, and has the staff already employed to fight these baseless claims. This is not just for me. This is for all the independent content creators who get bullied all the time. What happens if that letter was sent to somebody who didn't have the resources or the will to fight? They would just cave. I mean, for crying out loud, Wynton Yates, the lawyer who I employ that runs my New Orleans branch of my law firm, before coming over to the good guys and being a catastrophic injury lawyer, was trained as an intellectual property lawyer.
Sorry, Attorney Tom, I just gotta cut in. I really gotta talk about this cease and desist letter for just a second. You guys haven't formally met me. I'm lawyer Wynton. I run Attorney Tom's New Orleans office, and I'm an entertainment attorney that specializes in intellectual property. And this cease and desist letter has more holes in it than Camp Green Lake. Now, don't get me wrong. I am a huge advocate for protecting your intellectual property. The things that you create should be yours, and you should keep everybody from using it in a way that you don't want them to use it. However, this cease and desist letter totally disregards fair use. And fair use basically says that you can use certain copyrighted works for certain reasons, including commentary, criticism, news reporting, research, and education. And in this case, what Attorney Tom did with support court clearly falls within commentary, probably with a sprinkle of criticism. But in my humble opinion, I believe that if this fell in front of a judge, it would be fair use, it would be commentary, and it would swing in Attorney Tom's favor.
In the interest of still resolving the situation amicably, I'm still willing to link Miss Bailey's channel, but only if she calls me directly and asks, like she should have done originally. All she had to do was ask. And obviously she didn't have my phone number before this, but my office phone number is pretty readily available. And also, I have DMs, Twitter, Instagram. You can just DM somebody or email them. My email is freaking attached to all the videos that I do. Finally, this letter serves as a notice to you that AttorneyTom LLC's use of this footage is fair use. Should you be considering filing any legal action or DMCA takedown notice to YouTube or Facebook regarding these videos, you would likely be exposing Miss Bailey to civil liability pursuant to 17 USC section 512F. This section provides that if Miss Bailey misrepresents itself as a DMCA takedown request, it shall be liable for any damages, including costs and attorney's fees incurred by AttorneyTom LLC. Given the size of AttorneyTom LLC's following on YouTube and Facebook, the damages from a false DMCA claim would be substantial. And again, I want to reemphasize, my team failed to extend the courtesy to support court with Judge Vonda B. It is a pretty well-established act of goodwill on the internet for creators to tag creators who they are reacting to. That I acknowledge, and we failed to do that. But failing to extend a courtesy is not something that you can sue over. So there it is. I'm laying it all out there. If Judge Vonda B is watching this, I do hope we can get over this. I have a lot of respect for you and your channel. I think your videos are kick ass. And now that I know you're from Texas, I would love to be on support court. I think that would be tons of fun that we can get over this. But I take my responsibility as an independent content creator very seriously. I hope we can work this out. If not,
I'll see you in court.